Adele, can you hear us?
Yeah, got it.
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. We have one matter scheduled on our docket. It is an arraignment on a bench warrant. People of the State of Michigan versus Brandy K. Bedell. It's file 25.
This isn't just a routine courtroom docket. This is a layered legal drama unfolding in real time. One defendant facing multiple contempt allegations tied to suspicious drug tests, another entering a serious guilty plea involving a minor, and a third standing before the court with a long criminal history and one last chance before prison becomes inevitable. From bond revocations to plea deals and sentencing decisions, every moment in this courtroom carries real consequences. And as the judge weighs patterns of behavior versus second chances, the big question becomes, where does accountability end and rehabilitation begin? Stay with us, because what happens next might surprise you.
5-7039FH. Counsel, you want to state your appearances beginning with people, please?
Anthony Julia on behalf of the people.
Brian Clement, I have Brandy Bedell.
All right, good morning. And Mr. Klain is appearing by Zoom video. Ms. Bedell is appearing by video from the Sheboygan County Jail. Either one of you let me know anytime if you need a breakout room. And Mr. Klain, is it okay if I arraign her on the two other show causes as well at the same time?
Yes, sir.
Okay. So Ms. Bedell, it's alleged that you are in contempt of court by violating your bond conditions. That's in three different documents. Back on June 16th, the court signed an order to show cause for an alleged dilute drug test sample from 6/10. On 6/25, the court signed a second order to show cause for a dilute test on 6/20. And then on 7/22, the court signed a bench warrant for your arrest for dilute tests on 7/7, 7/10, 7/11, and 7/15. And you were lodged on that warrant yesterday from the courtroom on an unrelated matter. You've got the right to have a hearing on those allegations, where the allegation that you're in contempt of court would need to be proven by beyond a reasonable doubt. You have the right to the assistance of Mr. Klain at any such hearing to present evidence in your own defense and to question any of the witnesses presented against you. If you are found to be in contempt of court, you could be jailed for up to 93 days and or fined up to $7,500. Also, if I believe that you're not following the conditions of your release, I can modify or revoke that release. Do you have any questions for me about your rights or the penalties that you could face, or any need to talk to Mr. Klain about those two issues?
No, Your Honor.
All right, Mr. Klain, do you know how she wishes to plead to that?
Yes, Your Honor. At this point, we're asking the court to enter a plea of not guilty to the allegations. I would also indicate to the court that although I haven't spoken with Ms. Goodrich this week, we were just putting the finishing touches on a plea that would resolve the whole case in total. So I'd ask court to consider, I believe she's got a status conference coming up that's going to be a plea hearing. I'd ask the court to consider setting the hearing for the same time, I suppose. So maybe we can incorporate all this into the final resolution of the case, at least the pre-plea resolution to the case.
Okay. We'll enter a plea of not guilty as to the contempt. I see that she's scheduled a week from today for an arraignment on both cases that she has, this case and then a separate harboring a felon case. We'll schedule in this file, along with the arraignment, a status conference on the pending contempts for the same time as the arraignment. And Mr. Klain, let Mr. Juliet or Ms. Goodrich know if you'd like that instead to be an evidentiary hearing, and they'll notify any witnesses necessary.
I will.
All right. So as to any release between now and then, Mr. Klain?
Your Honor, I would be, and I understand that a dilute test is a serious allegation. I'd be more concerned if they're a positive test. I understand that a dilute test is treated as a positive test, but I'd ask the court to consider releasing Ms. Bedell. It's only a week until the next hearing, and even though it's just going to be the arraignment, I will tell the court that the work that we've done so far would result in this case, the whole case being resolved, both cases, the harboring of a fugitive and the possession of methamphetamine. So, with the posture of the case and the progress that's been made on the case, I'd ask the court to consider releasing her on bond.
Mr. Juliet, people's position.
Your Honor, I would ask that bond continue to be denied at this point. There were the two original show causes that the court signed, all for dilute tests, and now the bench warrant for several dilute tests that suggest a pattern that perhaps she is using. So I would ask that bond be denied.
All right, before the bind over, I see in the court file there was one dilute on June 4th. Then while the arraignment's been pending, we've sent out 2 show causes. While those are pending, I did a warrant for 4 more dilutes. Other test results we've had in June or July are 3 negatives and 2 more dilutes. That means over a 2-month period, she's been tested a lot, I think because the dilutes kept coming back. So the testing folks were trying to figure out what's going on. It's not many times I've seen 9 dilute tests in that short of a time. That raises serious concerns that she's using and intentionally masking that use, which is even more troubling than if she's just struggling and using and asking for help. So I think until I have a better sense of what's going on, I'm going to revoke Ms. Bedell's bond. I'll enter an order in both files so that we can be sure that she gets credit. Even though, well, I guess, Mr. Clayton, do you have an objection to that?
No.
I'm going to revoke it in 7038 until further order of the court and see where we're at with maybe any treatment needs or something like that. 7039, I want to make sure she would get any credit in that file. She hasn't, there's no alleged violation in that file, but I can enter an order revoking the bond in that. And if I do a reinstatement, it would of course apply to both.
Right.
Any thoughts about that?
No, that makes the most sense.
May I?
Well, Ms. Bedell, I'm sure that Mr. Clayton doesn't want you to say anything about the situation. I could put you in a breakout room so that you could run it by him and then see if he wants you to share what you were about to share with the court. If you want that, I'd be happy to do that.
That would be great.
Okay, so we're not going to go off the record yet. We're not going to conclude the hearing yet. I'll create a breakout room for Mr. Clayton and Ms. Bedell to speak briefly, and then we'll go from there. Back on the record and recalling the Bedell matter, the breakout room for the jail camera should be closing here. All right, Mr. Clayton.
We should be fine for today, sir. We'll see you next week, and hopefully we can get this all put together.
Okay, very good. We'll see you next week, Ms. Bedell.
All right, thanks.
We'll be adjourned. I'm going to call Mr. Warner's case. It's the People versus Keegan Warner, file 25-7004FH. Got Mr. Warner in the courtroom with his lawyer, Mr. Andriaki, the prosecuting attorney, Ms. Goodrich for the people. We're here for a docket call. Mr. Andriaki, how are we proceeding, sir?
Your Honor, with me entering a plea, if I may.
Warner, would you please stand and as best you can, raise your right hand for me, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can be seated. Are you Keegan Ray Warner?
Yes, sir.
Okay, Mr. Warner, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have. So I want you to listen carefully. At any time, if you have a question, ask me. I'm happy to answer. If you need a minute to talk to your lawyer, you just let me know. We're happy to give you that time. Is that all right?
All right.
Now, I have to advise you of the maximum penalty that you could face for the charges you're offering to plead guilty to today. And that would be counts 3 and 4. Count 3 is using a computer to commit a crime with a maximum of 4 to 10 years of the underlying crime. That is a felony punishable by 7 years and or $5,000 fine with reimbursement for the costs for government expenses and a discretionary consecutive sentence for the underlying conviction. Count 4 would be the underlying conviction accosting a minor for immoral purposes. That would be a felony punishable by a maximum of 4 years and or $4,000 fine. There's mandatory AIDS and STD testing. And there's it would be a tier 2 offense under the Michigan Sex Offender Registration Act, unless you have a prior tier 2 offense conviction, in which case it would be a tier 3 offense. So the discretionary consecutive means that the maximum exposure you would have would be the 7 years plus 4 years or 11 years maximum in the state prison. Mr. Warner, do you understand the maximum penalty allowed by law for those charges?
Yes, sir.
Are you on probation or parole anywhere?
Not currently.
Okay, were you on bond for any other cases at the time of this incident back in October 2024?
No, Your Honor.
Okay, did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
And did you sign that form today?
Yes, Your Honor.
Do you have any questions for me or for your lawyer about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you'll give up all those trial rights and you won't have a trial of any kind?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
All right, if I accept your plea, you're giving up any claim that the plea was caused by any threats or by any promises that are beyond the terms of the agreement. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission to appeal. You would do so by filing an application. Court of Appeals would not have to hear your appeal at all. If they did decide to hear your appeal, the types of issues that you could raise are very limited after a plea, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides that in exchange for your plea of guilty to counts 3 and 4, the prosecutor will dismiss the remaining charges. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Andriaki, is that a full, fair, and accurate statement of the terms of the agreement?
Yes, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Warner, other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you in any way to make you do so?
No, Your Honor.
Is entering this plea your own free choosing?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 3, using a computer to commit a crime punishable by at least 4 years?
Guilty.
How do you wish to plead to the charge in count 4, accosting a minor for immoral purposes?
Guilty.
So, Mr. Warner, back on October 1st of last year, 2024, did you have some communications with a person who was located in Sheboygan County?
Yes, Your Honor.
Was that person less than 16 years of age?
Yes, Your Honor.
Did you know that that person was less than 16 years of age?
Yes, Your Honor.
Were you using a computer program or a computer device to communicate with that person?
Yes, Your Honor.
Were you situated in Sheboygan County or no?
No, I'm in Abbott County.
Okay, but the person you were communicating with was in Sheboygan County?
Yes, Your Honor.
And during the course of that communication, did you have some communications of a sexual nature with that person?
Yes, Your Honor.
Did you ask that person to engage in any sexual activity with you?
Some pictures. Yes, Your Honor.
Okay. And you asked them to send photographs that would be of a sexual nature
Yes, Your Honor.
of them in an unclothed state?
Yes, Your Honor.
Okay. Mr. Andriaki, are you satisfied with that factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Mr. Andriaki, are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe I fully complied with the requirements of MCR 6.302?
I do, Your Honor.
Ms. Goodrich, on both those questions, your thoughts?
Yes.
All right, and Mr. Warner, I find that your plea is knowingly, understandably, and voluntarily made, and that there's a sufficient basis in fact and law to believe that you are guilty of those offenses. So I do accept your plea. You'll have to cooperate with a pre-sentence report where you'll be interviewed by an agent from the Department of Corrections so they can make recommendations about what I should do with you. I would presume you want me to know more about you than what I just learned right now. There's two ways that I learn about that. One is through you and your attorney at the sentencing, and another is through this pre-sentence report where I learn more about who you are. So we'll schedule sentencing for September 30th. Mr. Andriaki, morning or afternoon work better for you?
Afternoon would be best, Your Honor.
Okay. How about 3 p.m. okay?
Perfect, Your Honor.
So we'll schedule your sentencing, Mr. Warner, for September 30th at 3 p.m. Anything further from the defense,
No, thank you, Your Honor.
from the people?
No, Your Honor, thank you.
All right, we'll see you then, sir.
Thank you, Your Honor.
We're back on the record, and up next we've got sentencing and People v. Keith Gerlach, file 24-6912FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
And Mr. Nightingale, you want to place your appearance on the record?
Oh, please. No, not guilty. Here from Mr. Gerlach, who is here in person in custody.
All right, and we're here for sentencing on, we've got possession methamphetamine, a 10-year felony, R&O, a 2-year felony, drunk driving, a 93-day misdemeanor, sentence agreement for a county cap and a guideline range advisory scored at 10 to 23 months. And have you had a chance to review the report and recommendations with your client?
I have, Your Honor.
Any additions or corrections to the report?
No, Your Honor.
Any scoring challenges?
No.
All right, Ms. Goodrich, any scoring challenges or additions, corrections from the people?
No, Your Honor, thank you.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. So for Mr. Gerlach, Judge, he does have obviously some criminal history here. He's got 4 prior felonies, 10 misdemeanors. He comes before the court at 40 years of age. Very grateful for the agreement we were able to work out with the prosecutor here for this county cap. I think that it's fair and reasonable under the circumstances. What I would like to reiterate on behalf of Mr. Gerlach here is that his entire intention in pursuing this case has been to go to treatment, and I think that's really made clear in the PSI with his interview with probation that is his ultimate goal. His foremost goal is to get to treatment and have the court order him to do that treatment. He thinks that he does need that enforcement, that accountability from the court. It sounds like NDOC does not want to provide those services. I don't know if they don't want to provide it. They don't know that it's going to be useful for him, maybe is a better way to say it. Our position is that, in order to rehabilitate him and to reduce recidivism, that the court should order him into treatment. I think a reasonable period of incarceration here, he scores at a minimum of 10. We would ask for maybe a little less than that. And then to have him released to do treatment would be our preference at this point. If the court doesn't want to do that, then the court's sort of stuck with the 1 year and done. It's kind of the way that I read the plea agreement. So I think for the benefit of society and Mr. Gerlach himself, we would ask the court modify the recommendation a little bit to have him do a period of probation with treatment. He is still medication compliant as far as his mental health needs are concerned, even within the jail, which I think is great news. He plans to stay that way. I think he understands that at this point in his life, if he neglects that treatment, that he's going to suffer the consequences, not just in his personal life, but in the criminal justice system. Further, Judge, he does have good family support. His partners here today, his parents, from what I understand, are very supportive and upstanding members of the community, from what I hear. So, Judge, that's what we're asking for. If the court's going to order additional incarceration, we would ask that Mr. Gerlach be made eligible for trustee services. If the jail would also deem him eligible for that. I don't believe that he wants to make a statement, but of course he can change his mind.
All right, thank you, Mr. Gerlach. You don't have to say anything today, but you're allowed to. Is there anything you want to tell me or no?
No, Your Honor.
Okay. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant back on September 13th of 2024 had caused a car crash, which led to police involvement. His blood sample showed marijuana, amphetamine, and methamphetamine in his system. He also had a backpack with some methamphetamine and Suboxone in it, which led us here to today. He previously has served 5 terms of probation. 3 of those were revoked due to noncompliance. I think that's what led to the recommendations here today. Previously, looks like his longest time in jail was 8 months back in 2006. And then he served 5 other jail sentences, with the most being 93 days in jail. He did poorly on bond in this case in both district and circuit court levels, and which led to his bond revocation and why he's incarcerated today. I think that the 1-year jail is proportionate to what occurred as well as his performance on bond. Thank you.
All right, thank you, Mr. Gerlach. If you please stand for the court sentence. Mr. Gerlach, you're 40 years old. You have 4 prior felonies, 10 prior misdemeanors. You have a history of performing poorly on probation. You performed poorly on bond. In this case, drove on a suspended license. You were drinking. I revoked your bond. I'll dismiss the pending contempt citations. It doesn't seem like it's fruitful to really go forward with those hearings. But you didn't do well on bond. In this case, you were driving high on meth, and you hit another car. So you're a public safety danger as well. I agree with your attorney that some treatment would help you. The problem is you've been offered services and probation before. You've not complied. You didn't comply on bond. So I agree with the Department of Corrections that it doesn't make much sense to place you on probation because you've not complied with or benefited from any of the services we've tried to give you over a period of time. Now you're in the realm where you've got enough of a record that you're on a straddle cell. So you're getting awfully close to next time being a prison sentence. If I'm going to guess, I'm guessing that within the next 3 to 4 years, I'm sending you to prison for something else. That's what my money'd be on. So just remember that next time when you are here going to prison, that's the next sort of thing. So I hope that you make some changes you can prevent that from happening. I can't prevent that from happening. Mr. Nightingale, as skilled as he is, can't prevent that from happening. In any event, the advisory guidelines at 10 to 23 months, I think this is the kind of case where the county cap did you some good. And I'm going to follow the recommendations. Order that you serve that there's $186 in state cost, $130 in the crime victims assessment, $350 in court costs. And on the possession of methamphetamine and resisting obstructing, I'm going to order you serve 12 months in the Sheboygan County Jail with a credit for 47 days previously served. On the OWI, it'll be 93 days jail with credit for 47 days served. All 3 of those counts will run concurrent with each other. And I would indicate that on the judgment that the court has no objection to your participation in CBT or trustee programs in the jail if you are determined to be eligible for them. All right, Mr. Gerlach, you can appeal if you wish by filing an application to the Court of Appeals. If you wanted a lawyer, I'd give you one, but you'd have to make that request within 6 months of today's date. So we're going to hand you some of that appeal paperwork, ask you to initial 1 copy so we have a record we gave it to you. The other one's for you to fill out if you want to appeal. Do you have any questions for me, Mr. Gerlach? Okay, good luck to you, sir. Mr. Nightingale, I see a prison calling in. I presume that
this courtroom session brings together 3 very different outcomes, but one consistent theme: accountability shaped by patterns of behavior. In the first case, repeated violations and suspicious drug test results led to bond revocation, showing how quickly the court can act when trust is broken. In the second, a calculated guilty plea avoided trial but locked in serious consequences tied to crimes involving a minor. And in the final sentencing, the judge made it clear: when someone repeatedly fails probation investigation and continues dangerous behavior, the system begins to shift from rehabilitation to containment. The broader takeaway: courts don't just look at isolated incidents, they look at history, patterns, and the likelihood of change. And when those patterns point in the wrong direction, the outcomes become harsher, fast. Now we want to hear from you. Which decision stood out the most? Do you think the judge got it right in these cases? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.